Hello everyone, I'm Rashi Goel and I'm pursuing BLLB from University of Petroleum and Energy Studies, Dehradun. And currently I'm a legal intern at LEXIS and Company for the month of June. So the topic for my today's video is novation of a contract. Now, novation of a contract means creating a new contract while the old one is terminated and need not to be performed. It is an act substituting a new obligation or a party in a contract for the old one. Further, the newly substituted agreement should be valid, enforceable, have consideration, and should be by the mutual consent of the parties. Basically, it should fulfill all the requirements of a valid contract. When a contract is novated, the original contract ceases to exist and the parties have to follow the new contract. Section 62 of the Indian Contract Act states that if the parties to the contract agrees to substitute a new contract for it or to rescind it or to alter it, the original contract need not to be performed. Further, the basic requirement of Section 62 was discussed by the Supreme Court in the case of Lata Construction and others versus Dr. Ramchandra Ramniklal Shah. It was said that novation requires a complete substitution of a new contract in the place of the old one. And only in that condition the original contract does not have to be performed. The new substituted contract should be rescind or completely alter the terms of the original contract. Also, in another case of Ramdayal versus Maji Devdaji, the court held that the novation takes place by introducing a new terms in the contract or by introducing a new parties. A contract of novation requires a party to agree to extinguish or to discharge his obligation or debt. Unless this has been accomplished, there can be no novation. Therefore, the test is to know whether the parties intended to enter into a new contract between them or not. Also, it was held by the Kolkata High Court in the case of Juggi Lal Kamlapath versus NV International that for novation to take effect, modification to the contract must go to the root of the original contract and changes its essential character. Now let's talk about the types of novation. There are two types of novation of contract. First is change in terms of the contract and second, change in the parties to the contract. So first, let's discuss change in terms of the contract. The parties to a contract have the freedom to enter into a contract and alter its terms by mutual consent. When both the parties mutually agrees to change the terms of the contract which they have previously entered into, then the new agreement becomes binding on them. However, in case there is a clause in the contract stating that the terms of the contract can be altered by one party, that is unilaterally, such changes in the terms will be considered valid. Hence, a party cannot unilateral terms impose conditions that were not a part of the original contract. And the second type is change in the parties to the contract. Under a novation agreement, it is possible that the terms of the contract provides for the replacement of one party to contract by another party. This creates an obligation for one party in place of another party. Under this kind of contract, the new party assumes all the obligations under the contract and the party who has assigned his obligation to another party under such a contract will not be held liable for the future damages. For example, if A and B are parties to a contract and A agrees to replace C in B's place, then existing contract between A and B will cease to exist. Next is when novation of a contract is illegal. The court in the case of Ratanlal son of Pannalal ji versus firm Mangilal Mathuralal observed that if there is a direct connection between a fresh contract after novation and the earlier illegal contract or the earlier collateral contract, then the novated contract would still continue to be illegal or immoral, and the court would refuse to enforce the same. So now the next question which arises is when it is no novation. When the requisite conditions of novations are not satisfied, then it will be considered as no novation. The Kerala High Court in the case of Godan Nabotripad versus Kerala Financial that the essential features of a novation are the replacements or relinquishment of the right under the original contract by a new one. And when these essential features are missing, then there will be no novation. Thank you everyone for watching my video. I hope you like it, and if you did, please give it a thumbs up and share it with your friends and family. And don't forget to let me know your feedback in the comment section. Stay home, stay safe, stay healthy.